Yeah, as I stated, the LLC, the ownership are called membership interests. So they'd be like the analog to a corporation is like stockholders. So you can have a multiple owners, and then you can have their percentage of interest spelled out within the operating agreement. That may be something that is written in stone, or it may be something that's fluid in nature. It may be changing depending on if you take on other persons or investors, and they may get a membership interest, or you may sell out of your position in the LLC, and the other members probably are going to have first right of refusal to buy those interests before it goes to some other third party. So certainly the way that the organizational agreement or operating agreement is set up is going to outline how that all works, and that's why you need to have a professional set those things up for you instead of just grabbing a form and go, okay, this works for us, because it's almost never a one-size-fits-all, and everything is great unless, until somebody complains, whether it's somebody within the organization or somebody outside, and then everybody goes to look at this agreement, and if it hasn't been done correctly or done by somebody that's trained or somebody has the experience in it, then what's going to happen is that you're going to wish that happened, because those things may be ambiguous, they may not be in the agreement at all, and then the judge or the jury may interpret those things in a way that's not beneficial to the person that's contemplating organizing this business, whether it's with other members or not. So it's very, very important, especially if there's more than one person, then there certainly could be internal fighting as opposed to somebody coming from the outside suing or making a claim. So if you're having obviously more than one member, you certainly need to have a really, really sound operating agreement. Not saying it solves all problems, because attorneys are not psychic, at least myself, I'm not. But so you try and anticipate, based on your experience and based on the nature of the business, things that can go wrong and how those things would be resolved in the agreement. And that way everybody has kind of a clear understanding of what their responsibilities and obligations are if something were to go wrong, and what the remedies are as well if something goes wrong against another member. So that should all be spelled out in the operating agreement, which should be done by somebody that has knowledge in regard to setting up business organizations.